Today we are going to discuss about the inherent powers of the High Court, which is provided under Section 482 CRPC. The section in itself having three keywords. If we break the bare section, that will provide three parts. If we will read, it will like this: nothing in this code shall be deemed to limit or affect the inherent power of the High Court to make such order. The operative part is to make such order as may be necessary to give effect to any order under this code. This means, suppose any order has been passed by any court which is subordinate to the High Court. The High Court having the power, what High Court can do is they can pass an order for the implementation of the order passed by the court below. The section provides in itself. Second part is that, or to prevent abuse of process of law of any court. Suppose any order which is in itself is abuse, like a person who has been charge sheeted, and as per the person who is accused, the charges which were mentioned in the charge sheet does not attract the offense. What he has the authority, he can file a 482 petition before the High Court so that abuse of process of court of law may be prevented by the High Court. Third part is that the powers of the High Court was in the third part of the definition in itself, like or otherwise to secure the end of justice. This is the part where High Courts come into existence in itself to pass any order. This is the bare provision which 482 provides in the Act. Like, first we come to the what is the need of 482. The need of 482 is, suppose, to secure ends of justice first. Second, the things which is provided in the CRPC, and there is any order which was passed by the court which in itself is preventive or having abuse of process of law, that must be challenged by the High Court under Section 482 of the CRPC. Like the examples are, suppose A ने B का मर्डर किया, C was the eyewitness, D is the father of B, and E is the brother of B. Now C is the eyewitness. What he do? पुलिस स्टेशन जाता है, एक FIR ए के खिलाफ दर्ज कर देता है. एक FIR तो C ने फाइल कर दी ए के खिलाफ. What is the next thing is, D जो फादर है B का, उसने भी एक FIR दर्ज कर दी ए के खिलाफ. अब ब्रदर जो है E, उसने भी कर दी फाइल. अब ए के कॉज ऑफ एक्शन के लिए ए पे 3 FIR हो गई. अब कहीं लॉ तो प्रोवाइड कराता नहीं है कि FIR बार हैं, FIR तो हो सकती हैं, लेकिन उसके पास क्या रिलीफ बचता है ए के पास? तो वो 482 CRPC में जा सकता है और कोर्ट उस पर ऑर्डर पास कर सकती है कि 2 FIRs को क्वैश करेगी और एक सिंगल जो FIR है उस पर फर्दर इन्वेस्टिगेशन का ऑर्डर कर देगी. तो ये 482 की हमारी पावर्स होती हैं. अब हमारे आता है व्हाट आर द पैरामीटर्स of the inherent powers to quash FIR or any other case. The basic rule has been provided in the judgment of State of Haryana versus भजन लाल. उसमें की पॉइंट्स दिए थे आपका 482 एग्जिस्टेंस में आ सकते हैं. 482 कोई सिंपल लॉ नहीं है कि कोई भी आएगा उसको फाइल कर लेगा. वो खाली एक्सेप्शनल केसेस में आ सकता है. 482 एग्जिस्टेंस में तभी आएगी जब कहीं पे भी, जैसे किसी भी स्पेशल कोड है या लॉ है, किसी भी एक्ट में प्रोवाइड किया है, वहां 482 को एग्जिस्टेंस में नहीं ला सकते हैं. 482 तभी आएगी जहां एक्सेप्शनल केसेस होंगे. एक बेयर प्रोविजन की तरह इसको यूज नहीं किया जाएगा, नहीं तो ओवरबर्डन हो जाएंगे सारी कोर्ट्स. अब जैसे स्टेट ऑफ यूपी वर्सेस भजनलाल में की पॉइंट्स दिए गए थे कि कब 482 मेंटेनेबल हो सकती है. जैसे एनी ऑफेंस प्राइमा फेसी ऑफेंस होता है नहीं होता है एक्यूज के खिलाफ। दूसरा, एलिगेशंस में कॉग्निजेबल ऑफेंस है या नहीं है। एविडेंस जो कलेक्ट हुआ है वो सफिशिएंट इनफ है या नहीं है एक्यूज को दिखाने के लिए। चौथा है, प्रोसीडिंग्स मैलिशियस हैं तो 482 एंटर करेंगे, नहीं तो नहीं होगी। लाइक रिसेंट केसेस में आप देखेंगे 498 ए में 90% केसेस में मैलिशियस प्रोसिक्यूशन के केस ही होते हैं। अब रिसेंटली आप जजमेंट ले सकते हैं अर्नब गोस्वामी का। अर्नब गोस्वामी वर्सेस स्टेट ऑफ महाराष्ट्र में कोर्ट ने स्पेसिफिकली बोला, while quashing a petition, the High Court is duty bound to undertake a prima facie evaluation of whether the ingredients of the alleged offence have been established in the FIR or not. That means it is necessary. कोर्ट्स हमेशा देखें कि क्या प्रेमा फेसी ऑफेंस एक्यूज के खिलाफ बनना है नहीं बनना है, ऑफेंस कॉग्निजेबल है, क्या प्रोसीडिंग्स तो नहीं हो रही हैं एक्यूज के खिलाफ। और स्टेट वर्सेस भजनलाल 1990s का केस है, इसमें ही पूरा एक स्टोन लेट डाउन कर दिया गया था 482 के रिगार्डिंग। सेम वाज लेट डाउन इन द आरपी कपूर वर्सेस स्टेट ऑफ पंजाब। अब जैसे हम थोड़े से एग्जांपल देते हैं, जैसे आई एम प्रैक्टिसिंग एट इलाहाबाद हाई कोर्ट। हमारे यहाँ 482 पिटिशंस में बेसिकली जैसे चार्जशीट चैलेंज होती है प्लस समनिंग ऑर्डर। जब चार्जशीट आ जाती है उसके बाद समनिंग की जाती है एक्यूज की, द पर्सन्स हु आर एक्यूज इन द चार्जशीट, उनको समन किया जाता है। तो व्हाट वी चैलेंज इज चार्जशीट एज वेल एज द कॉग्निजेंस ऑर्डर, जिसमें हमें समन किया जाएगा। सेकंड थिंग इज, अलग हाई कोर्ट्स में 482 में एफआईआर क्वैशिंग में भी जाते हैं, बट इन इलाहाबाद हाई कोर्ट हम लोग एफआईआर क्वैशिंग में नहीं जाते हैं, क्योंकि ये अपने अपने कोर्ट्स की व्यूज हैं, वो किस चीज को एंटरटेन करेंगे किसको नहीं करेंगे। तो 482 अपने आप में वाइड एस्पेक्ट है, हमारे यहाँ कोर्ट्स एंटरटेन नहीं करती हैं एफआईआर क्वैशिंग्स को। बेसिकली हम लोग जाते हैं जो कोर्ट्स में प्रोसेस शुरू हो चुका है, उसके बाद ही हम लोग 482 में जा सकते हैं। लाइक इन कंप्लेंट केस, लाइक 138 है, समनिंग हो गई है, तो समनिंग के खिलाफ हम लोग 482 में चैलेंज कर सकते हैं। रेस्ट डिपेंड्स अपॉन द कोर्ट, वो क्या रिलीफ प्रोवाइड करा रही है। नेक्स्ट थिंग इज, वी विल डिस्कस द निहारिका जजमेंट दैट वाज रिसेंटली पास्ड। सुप्रीम कोर्ट ने इसमें स्पेसिफिकली बोला है, लाइक कोर्ट्स क्या करती हैं, इंटरिम ऑर्डर पास कर देती हैं डेट टिल डेट ऑफ नेक्स्ट हियरिंग नो फर्दर एक्शन शैल बी टेकन, और या फिर इन्वेस्टिगेशन को स्टे कर देती हैं। तो सुप्रीम कोर्ट ने निहारिका इंफ्रास्ट्रक्चर प्राइवेट लिमिटेड में सीधे बोला है, अगर आप एज सच ऑर्डर पास कर रहे हैं तो दैट मस्ट बी अ रीजनड ऑर्डर, नॉट इन अ जनरल वे। स्पेसिफिकली इंटरिम ऑर्डर्स जो पास किए जा रहे हैं उनमें एक ब्रीफ फैक्ट्स होना चाहिए, रीजन होना चाहिए कि आप ये सच ऑर्डर क्यों पास कर रहे हैं। लाइक हम बात करते हैं प्रोटेक्शन ऑफ अरेस्ट पे, हर कोर्ट्स की अपनी अपनी डिफरेंट व्यू है। जैसे इलाहाबाद हाई कोर्ट में आप अगर स्टे चाहते हैं अरेस्ट पे, तो यू हैव टू फाइल अ पिटीशन अंडर आर्टिकल 226 ऑफ द कॉन्स्टिट्यूशन, बट इन अदर हाई कोर्ट्स 482 पिटीशन इज मेंटेनेबल। Like recently a judgment was passed in, I think, March in Supreme Court, रवेरी कृष्णा मूर्ति वर्सेस स्टेट ऑफ तेलंगाना, जिसमें कोर्ट ने साफ साफ बोला है, हाई कोर्ट कैन नॉट ग्रांट इंटरिम प्रोटेक्शन फ्रॉम अरेस्ट अंडर सेक्शन 482 CRPC आफ्टर डिसमिसिंग अ क्वैशिंग पिटीशन। दैट मींस suppose we have filed a quashing petition for quashing of the FIR, and our main prayer is to quash the FIR, but our interim prayer is to not to arrest the petitioner till the submission of the charge sheet. In this condition, the court has refused to grant the main prayer to quash the FIR. In such situations, the Supreme Court has said, if the main prayer has been rejected, then courts cannot allow the interim prayer of the petitioner. In other words, we can say कि हमारी मेन प्रेयर है कि क्वैश कर दी जाए एफआईआर, और इंटरिम प्रेयर है कि हमें अरेस्ट ना किया जाए ड्यूरिंग इन्वेस्टिगेशन। तो सुप्रीम कोर्ट ने वही कहा है कि जब आपने मेन प्रेयर एफआईआर क्वेश्चन की खत्म कर दी है तो आप उसको इंटरिम रिलीफ नहीं देंगे. दैट्स व्हाट हेल्ड इन निहारिका केस. Whereas it was also held by Supreme Court in various cases, while such restrictions are necessary, placing strict guidelines on the exercise of power under Section 482. This was the principle which was again and again Supreme Court is saying to be passed in 482 petitions. Next, we will discuss about the stay on investigation. Stay on investigation basically is such a thing like FIR has been registered against a person. What relief he may granted by the High Court is he can approach High Court under Section 226 or 482. It is his discretion, but every High Court has his different point of view. Like in our High Courts, in Allahabad High Court, court basically entertain petitions under Article 226 for stay of investigation. Same was applicable in protection of arrest. So in our High Court, the 482 petitions for staying of investigation or protection from arrest are not maintainable, but the same are maintainable in other High Courts. The judgment, Bhajanlal judgment, was recently reiterated by the Supreme Court in a judgment of Prabhat Bhai Ahir versus State of Gujarat in 2017. Whereas again and again the Supreme Court is saying while passing an order under Section 482, it is mandatory to the High Court to give a reasoned order before passing any such order. Like in the case of Kapil Agrawal and others versus Sanjay and Sharma, there is specific provisions has been provided by the Supreme Court to entertain such petitions.
.482 only 3 grounds are there. Only 3 grounds. Okay. Under 482. One is number 1, error apparent on the record of the case. There is a gross error. Okay. Incurable. Okay. Number 2 is it is the FIR, whatever it is a sheer abuse of process of law. Okay, for 482. And the third and foremost is that the trial is not required to be carried out. That is, in one sentence, there is a gross miscarriage of justice. Okay, these are the main 3 grounds. That error apparent on the record of the case. Number 2, sheer clear abuse of process of law. Third, gross miscarriage of justice. Then only the High Court can interfere under 482. Then there are 2 aspects. Whether only FIR registered investigation is there, whether 482 petition can be entertained. If convenience on these 3 grounds, if the High Court is convinced, otherwise the normal law is even High Court or Supreme Court cannot interfere in the investigation. Investigation is a absolute right of the investigating agency. Then comes only after filing of charge sheet. So after filing of charge sheet, that the 482 can be entertained, as is said in Allahabad, that you have to go for not to protection or under 226, but all other, at least I speak for Bombay High Court myself. So Bombay High Court 482 is entertained. Only the main grounds is this, that error apparent on the record of the case, that error cannot be rectified, incurable, abuse of process of law, entire charge sheet is read, there is nothing going to be, unvetted, unrebutted. It will not end in conviction. Then third is gross miscarriage of justice. That's all. This I want to add. Okay. Keshav, okay?
Yes, sir.
Keshav?
Yes, sir. So that's actually, it's not just okay, sir. It's actually quite great, and it's very
Yes.
informative also.
See, that
If
is
you want to
why.
share some
Then
information.
what is the precedent? What is the principal law? 482 is not going. 482 is only to be allowed only in rarest of rare cases. It is not as an absolute right. You cannot go. Rarest of rare cases, justifying the very filing of 482. Otherwise, the other side is also there. No, whether complaint, whether it's FIR, whether it's a private case, whatever it is, whether, and also court also will see whether I Court 482 way that suppose in there are two chapters. In my future lectures which I'll cover, there is police reports and other than police complaint 19 and 20 of CRPC. So whether see like in charge sheet is filed, accused an option of going for 239 discharge. Okay. In then in private cases other than police complaint 240 245 1. So all this will come into play. So 480 is not an automatic remedy. It is a remedy which is usable whenever the situation arises, justifying it file the 482 petition. That's all. And absconding is a different issue. Whenever absconding comes, there is a procedure laid down in CRPC that for a person actually then under section 62 of CRPC, summons have to be served personally. That is one. And second is availability of the accused, whether he is on bail or absconding from the beginning. So, yeah, ordinarily, this proclamation is issued. After proclamation, then 80 to 86, all these sections are there. Then there will be, if the property of the accused is there, then that will be attached and forfeited by the state. All these procedures are there. So when you are applying for proclamation or absconding accused before the High Court, one must justify why High Court interference is required, why is absconding. See, available to the system of administration of justice is a primary concern of the law. Because just on the other day, he spoke very well, our CJA, rule of law, rule by law. Rule by law is different, rule of law is different. Why the legislature has intended 482? Only three reasons. That error apparent on the face of the record, that it cannot be so. FIR cannot be. For example, I can give you 498A is more misused than used. That, adding all the family members, everything. So, which is not there. So, is to protect such 482 is envisaged and introduced by the parliament in their wisdom to then abuse of process of law means it is day in day out. Somebody influences and then records FIR, there is no offense committed, there is absolutely not an iota of evidence against them. So against that is clear abuse of process of law. And third aspect is gross miscarriage of justice. Gross miscarriage of justice means provisions of law, the legal provisions applicable are not followed and bypassed or ignored or looked over while registering FIR, and there is no fear. Like, for example, investigation. Investigation, there are 4-5 principles which are absolutely established by Supreme Court and High Court judgments. Investigation should be absolutely fair, independent, credible, reliable, uninfluenced. Okay, all these protections are there. All these protections are there. What that Allahabad High Court judge, the advocate who has been lecturing, nicely said, Bhajanlal case is a Bhajanlal case. They have set out grounds. That is why any High Court has to give reasonable order. Coming to your question, that absconding accused Haryana wo kar raha, ye kar raha. No, that each case is different set of facts. We cannot blanket out all cases under one roof. That why that absconding is there, why proclamation is issued, what whether is available, what are his grounds for going under 482 have to be considered judiciously and by the provisions of law. Am I clear?
Yes, sir.
Am I state one point? Abhishek Singh from Bombay High Court.
Yes, sir. Please continue.
Yes,
Tell
yes.
us.
That quashing word has a very big impact, and it comes in the interlocutory orders also, as well as final orders also. So when the quashing order is passed under section 482 in the favor of the accused, then the whole case gets finished. And proclamation is an interlocutory order. Proclamation order is just only an interlocutory order. So there is a huge difference between an quashing order in 482 and quashing order of various other natures of interlocutory orders like proclamation, non-billable warrant, and many other things, which under which the reliefs are not being granted by the lower courts and the lower appellant courts. Then then the person approaches to the high court to get the relief. So that quashing word is used in a many senses. That has to be noted. Thank you, everybody.
Definitely, definitely. Sai sir has, sir, thank you so much. You've actually very well expounded on the entire concept that it is not something which is, it is not a power which is to be used liberally. As a matter of fact, it is to be used very judiciously and very sparingly, for that matter of fact, as has been said in so many instances by the Honorable Supreme Court itself.
Exactly. When situation is demanded by the merit of the case. That's all. That's it. That explains it. By merit. Merit demands that should be considered under 40. He nicely explained. Even he brought out this Goswami's case, and also he is brought out. See, regarding there are FIRs filed. Now sedition cases and all. Sedition law is a British law, and also now that Telangana's case, Krishna. As case he has suggested where Supreme Court. So Supreme Court there, that allowed it because there it is persecution is not allowed. Prosecution is different. Persecution means ignoring the laws. Exactly. In Bombay, actually, there is another. Before 482, there is authority started SPCA. Okay, State Police Complaint Authority, SPCA. So against any FIR, any police excesses or any misuse of provisions of law under IPC, CRPC, the person is having a complaint grievance authority, that is SPCA, State Police Complaint Authority, where he can lodge a complaint. Apart from this, the Human Rights Commission is there. Both are the State Human Rights Commission and National Human Rights Commission. So these are also available. So when a case demand on its merits, then only 482. This is my humble submission, subject to any corrections. Okay, Keshav?
Yes, sir. Yes, sir. So I was just thinking about this one particular thing which you've mentioned, and I think in all, with all advocates for that matter of fact, it definitely does resound that wherein you said that in meritorious cases or wherein in situations or circumstances that deserve. So, alright, so let me, look at it from a perspective of an advocate who is just starting off or who's probably trying to understand the ambit of Section 482 or who is learning. And from that respect, sir, like with respect to the juniors who are practicing also, where exactly do we draw that line? And how exactly do we draw that line before we have to, let's say, even consult with our client, with a client, and we have to advise him, for that matter of fact, that this may be an appropriate remedy, or that where does the advocate come, apply their judicious mind, and how do they come to an observation that this case would probably deserve?
Absolutely, very good question. Very good question. It depends upon first the facts in hand, and second the application of provisions of law. Okay? In a given set of facts, the application of provisions of law are not falling under only these three categories. There is no fourth category, my dear Keshav.
Yes, sir.
Mind you, fourth category is not there. Error apparent on the face of the record, sheer abuse of process of law, gross miscarriage of justice. Because you are going to High Court means High Court is the highest court of the state. Okay. So it is not it. So it depends on each set of facts of the case. Fact. What they have said first, they must get to the facts and applicability law. I advise all my junior brothers who have come in are students. In such cases, it is better, always better to take an opinion of a retired judge or a retired SG, Solicitor General or AGP, who have experienced all this, and they will correctly say where the case of the client stands and what is the probability of getting relief. And on depending on the ultimately, client will be satisfied only when he gets a relief. So for that, a case when you are going before the High Court, it is on the mostly in High Court facts they consider, but at the same they apply the first law. Rule of law is applicable. So rule of law, points of law only give that power of quashing. So on these two, whoever is in confusion or whether to go or not, they must seek either seniors advice or retired judge advice and take an opinion even in writing also. If a client can afford from a retired judge who can definitely after going through the facts consist of that eyewitnesses, witness statements, documents seized, and a Panchanama recovery. So all these facts will be considered and they will weigh the case whether it is a fit case to go before High Court under 482 for setting aside or quashing.
Sir, my
Am I
question.
clear?
Yes, sir.
Advocate Abhishek Singh.
See, that is why this is inherent powers. Like in CPC, inherent powers under 151 is there. That is even with the even trial courts also there under CPC. So here inherent power means that 482 High Court can use their inherent power for quashing or setting aside a charge sheet, even FIR. At the stage of FIR, it is absolutely falling under these three categories, and that is why you have seen in certain cases even High Court is monitoring the investigation, where investigation is detracked or the provisions of law is ignored, and the prosecution is not applying the law properly, then that is again miscarriage of justice. It falls under a broad category.